Hey everybody, I'm Joe Murphy. I'm an immigration lawyer with Allegheny Immigration Group here in Pittsburgh, Pennsylvania. My practice focuses primarily on humanitarian and family-based immigration, and I handle cases all over the tri-state area. That's Pennsylvania, West Virginia, Virginia, Maryland, and I also have a book of business in San Francisco. I'm on here live to take your immigration questions. While we wait for people to come on, let's talk a little bit about immigration. This is a big question in a lot of people's mind. How does our immigration system work? What are the rules? There's a lot of talk out there, a lot of rhetoric, a lot of it is misleading or confusing. Everybody who enters the United States legally, and that is admitted through immigration, enters in one of two very broad categories. They enter either as an immigrant or as a non-immigrant. An immigrant is someone who is entering the United States to move here permanently. Maybe it's someone who married an American citizen coming in to live with their spouse, or it could be someone who's been sponsored for permanent employment in the United States. A non-immigrant is someone who's entering for a temporary purpose, and that could be a visit to the Grand Canyon, getting a medical procedure here in Pittsburgh at the University of Pittsburgh, attending classes. Those are all non-immigrant entries. Non-immigrants are not becoming Americans. They're just here for some temporary purpose. Immigration officers presume that everybody wants to move to the United States. So when you're applying for a non-immigrant visa, whether that's a tourist visa, which would be a B visa, or a student visa, which is an F visa, or any other non-immigrant categories, you're presumed to have the intent to immigrate. You're presumed to be wanting to move into the United States. And the applicant for a non-immigrant visa has to go to the embassy and speak with an immigration officer and overcome that presumption of intent to immigrate or intent to become an American citizen. How to do that? Okay, so the immigrant has to prove they have significant ties with the home country. They have to prove that there is not significant ties with the United States, that there's not only nothing pulling them here, but there are things pulling them back to their home country. Things like a job in the home country, family members left behind, significant property holdings in the home country that would have to be abandoned, tend to illustrate a significant tie with the home country. At the same time, you have to look at what they're doing in the United States or what they plan to do, and whether doing that in the United States would destroy those ties. So if someone's entering and claiming to be a tourist and is trying to overcome the presumption of non-immigrant intent by illustrating he has a job as a executive at some company in Germany, if he's asking to stay for 6 months, some inquiry might be had into whether staying away from Germany and away from his work for 6 months would destroy that job and therefore part of the things pulling the immigrant back to his country of origin. Ultimately, and this is an unfortunate reality, most of these things are done unilaterally by the intending non-immigrant. You no longer need an invitation to come visit the United States. The immigrant can simply go online and fill out the request. It's a form DS-260, I believe. It's online. And submit that and a photograph. They print out the first page of the DS-260 online application, and then they'll call the local embassy or consulate and make an appointment to come in for an interview. The intending tourist, non-immigrant, should go to that interview and take with them proof that will help them overcome that presumption of non-immigrant intent. Things like leases or property ownership records, proof of a job, planned places that they're going in the United States as opposed to just coming in with no stated purpose or thing to visit. Those are all very nice things to have to help a consular or embassy immigration officer evaluate the immigrant's claim that there is no immigrant intent, or more importantly, overcome the presumption that there is. The rough part about that is that the immigration officer that reviews these things and makes that determination is part of the State Department, and the State Department has tremendous discretion in who they let into the United States. So, for example, if the application for non-immigrant visa is denied, there's no appeal. There's no supervisor to complain to. There's no way to relitigate that. It's just a final decision, and it's done in a summary fashion by someone at the embassy or consulate. So I suggest, perhaps, especially where the intending non-immigrant to the United States, the visitor, so to speak, has been denied before or anticipates trouble, that might be a good time to talk with counsel about preparing evidence of non-immigrant intent. And one of the interesting things about non-immigrants is that they're not allowed to work here. Without special exception, non-immigrants can't work, and any working for profit would be a violation of the non-immigrant status. The presumption here is that, again, is an act of moving in, which is in violation of the stated purpose of that visa. Other things that would violate non-immigrant status, if the non-immigrant status is premised on attending classes, if the F student visa holder were to drop out of school for a significant period of time, the school itself, as the sponsor of the non-immigrant, would notify USCIS of the student's failure to attend classes, and then the visa would be revoked. For those of you who are just tuning in, I'm Joe Murphy. I'm a lawyer with Allegheny Immigration Group here in Pittsburgh. I handle humanitarian and family-based immigration matters. Our number is 412-586-4131, and our website is AlleghenyImmigration.com. And any of you have questions, you just go ahead and you can type them into your question bar. I'll be happy to take and answer any questions. I had been talking about non-immigrants, that is, people who, when they enter the United States, disclose a temporary purpose. They prove that they're not trying to move in, that they're coming just for something temporary. And the examples I gave were students who were just coming to take classes and would go home after the classes were over, or perhaps someone who just wanted to visit the Grand Canyon or was coming here for a medical procedure. Those are what are called non-immigrant entrants. The opposite of that would be an immigrant entrant. That would be people who are coming to the United States really to move here permanently. And one of the examples I gave was the spouse of an American citizen. Someone got married in, for example, Spain, and the wife was coming in not to stop in briefly, but to come here and live permanently with her husband as an American. Those are what immigration law calls immigrants. And so the non-immigrants are temporary entrants, and they're going back, and the immigrants are moving here forever. And some of the discussion we had before the few viewers I have came on, and thank you for checking in, we were talking about the non-immigrants, and they have to overcome the presumption that they're going to move in. And that's the law. They're presumed to want to be Americans. They're presumed to want to move in, and they have to overcome that presumption of immigrant intent during an interview at the consulate or embassy that they're seeking to get a visa issued from. And the examples I gave of things that could help a potential non-immigrant overcome the presumption that he or she intends to move in permanently and become a United States citizen would be evidence that there's significant things pulling them back to the home country. Things like property ownership records, a job there. Oh, hi, Dinesh. Dinesh is asking a question. Let me see what it says. He's a green card holder. Okay. All right, there's a couple ways to do that. A green card holder can sponsor his family members, and that would be spouse and children under the age of 21 at the time the application is adjudicated. It's a lot longer for a green card holder. It takes quite a long time because you don't get that first preference that a citizen does. One of the interesting things we can do for you, however, if you're getting close to a point where you could adjust and become a citizen, is get your application in now. And then we could actually upgrade the status of the application later when you did get your citizenship, and then your wife would be a first priority immigrant. If you wanted to leave a private message with a phone number or something, I could call you after the show or tomorrow, and we could talk about that some more. I could show you how to do it. But that's a really effective way of getting your spouse, so to speak, in line, because you'd get the priority date of filing now, and then we would upgrade her, or upgrade the application later to show that you were a citizen and had become a citizen, and that would make your wife and kids first priority. Now, let's see. Ashkan has a question. Okay. He's an Iranian student studying in the U.S., and he has an issue going back to visit. It's a bigger question. Let me see. More. I can't see all of your question, Ashkan. I got all the way not being able to go back to visit. Would you submit the rest of it in the second question? So anyway, Dinesh, that's commonly done where you apply in the permanent resident status to get a filing date and then upgrade it later when the permanent resident adjusts to citizen. Can you guys hear me okay? Would someone just give me a sound check? We hear you, something like that. All right, well then I'll continue talking. Maybe Ashkan, if you can send another message because of that, I can't get your message got cut off in the little ball. There you go. Okay. Okay, so Ashkan is asking about traveling back to Iran. He's here as a student. Probably not. He's asking if he'll face difficulty coming back. You have a student visa that authorizes your entry into the United States for the non-immigrant purpose, and we were discussing the non-immigrant or temporary purpose of studying in the United States. I would think that for summers, when you're not in classes, it would be perfectly normal for you to go home. As long as the underlying visa, that is your F1 visa, I believe, for a student, is not expired, you're admissible to the United States. And that should be honored. Now, of course, if you've done something in the meantime that violated your F student status, for example, dropped out of classes or were caught working, then you become inadmissible, and that's correct. If you left, they would not let you back in the United States. I hope that helps. Is that any good? So that's a good point, and we discussed this as a matter with the presumption of immigrant intent and the non-immigrant visas that people have. They could violate the terms of their visas by doing any number of things. For example, well, let's start over, okay? If you're admissible to the United States, you've demonstrated, you're very welcome, Ashkan. And if you'd like to send me a PM with your phone number in it or an email address, I'll try and reach out to you, and perhaps there might be some confidential details you'd like to discuss. I'll be happy to do that with you. You can just... Oh, sure. Dinesh is asking the name of the office. Again, my name's Joe Murphy. I'm a lawyer with Allegheny Immigration Group here in Pittsburgh. Our office is in the Grant Building. That's at 310 Grant Street. The phone number is 412-586-4131. And our webpage is AlleghenyImmigration.com. You've also obviously got here through the Facebook page, and that's a good place to follow. I encourage both of you, Ashkan and Dinesh, to follow our Facebook page in particular. And the reason why is we're constantly putting out information, tips, tutorials, ideas that could be interesting or valuable to you. Yes, of course you could send a message in Facebook Messenger. That's perfectly fine. If you have something confidential to talk about, I discourage you from using Facebook Messenger to disclose anything confidential. Obviously, Facebook monitors everything, and it may or not be held to be a violation of attorney-client privilege if you were to disclose something untoward, illegal, or of that type in a Facebook message. Now, I also ask that you guys would share the page, join the page, and perhaps even share this live. We're trying to provide a service here to people to help them understand immigration law. And if you can help others, if you find it helpful, I'd ask you to share this video. All right, now let's see. Ashkan, Dinesh, okay, you've got enough information about the office. Thank you, and I appreciate your interest. So we were talking about the general category of admissibility. So for anybody to get into the United States legally, entering the United States legally is called admitted. That's being admitted to the United States. So being issued a visa of any type is a preliminary determination that you are admissible for the purposes you've asked to be admitted. So someone who asks to be admitted as a tourist and comes to immigration, and when they ask what he plans to do in the United States, says he wants to be a student, is not admissible for that purpose. He's got a tourist visa, not a student visa. There are other ways of becoming inadmissible that are not purpose-based. For example, people who lie to immigration authorities are permanently, it's a lifetime ban, and you're inadmissible for the rest of your life. If you're a drug addict or carry infectious diseases, you're inadmissible. So a visa is issued, and you finish a flight, and you come to the immigration desk. You wait in line, you come to the immigration desk at the airport, you present your visa. The issuance of the visa is a preliminary determination that you are admissible to the United States. When you present at immigration, that is a process that in immigration law is called inspection. And this dates back, honestly, to ancient times of sailors and stuff, where ships would pull up into a port, and as sailors were getting off, the local constable or sheriff would physically inspect the sailors leaving the ship to see if they had, for example, obvious diseases or were obvious troublemakers. When you're inspected by customs agents, they're checking your visa. That's the preliminary determination that you're admissible. They're asking information about your purpose, perhaps where you'll stay. And those are things to say that you were admissible at the time the visa was issued, and you remain admissible. I recently looked at a case where a young woman was issued a tourist visa to enter the United States, when in fact she was intentionally trying to get in the United States to get advanced treatment for a serious drug and alcohol addiction she had. She wanted to check into one of the more successful and posh rehabilitation centers. Obviously, this woman was afraid to disclose her drug and alcohol addiction status to immigration officials because that would have made her inadmissible. So she said she was just coming as a tourist, and now she's committed two separate immigration violations. One, she's inadmissible as a drug addict. Two, she lied to immigration officials to get past that. So those are some other grounds for inadmissibility. Of course, people who plan to overthrow the United States or practice polygamy or who are here to engage in human trafficking are also going to be inadmissible as criminals and terrorists. We had those two guys that had some interesting questions. I really appreciate that, and I do ask that you share this. I think this will probably be the first live of many. If it becomes popular, I'd certainly enjoy talking about immigration and immigration-related issues. Once again, my name is Joe Murphy. I'm an immigration lawyer with Allegheny Immigration Group here in Pittsburgh. I practice primarily in family and humanitarian immigration applications. Our number is 412-586-4131. Our website is AlleghenyImmigration.com. And I ask, too, that you share this page and live with friends. I'm always happy to talk about immigration. It's something I really feel passionately about and I really like doing. You can get wonderful things for people as an immigration lawyer, up to and including citizenship. And I do encourage the two of you to look at our Allegheny Immigration Group Facebook page, because there's always interesting updates, stories. There was a recent expansion of what's called expedited removal in the United States that the Trump administration pushed through. Everybody knows that people can be deported. In immigration law, that's actually called removal. Someone who, for example, violated their admission status by working or stealing or lying to immigration officials is inadmissible, and therefore someone who's been admitted and then is later discovered or becomes inadmissible is subject to removal, and that's what's commonly known as deportation in common talk. So the rule for a long time was that people who, so to speak, walked into our country over the land borders, if they were here for less than 14 days and were caught within 100 miles of the border, they could be subject to expedited removal. Think accelerated deportation. Very, very quick process intended to get them back in their home country, so to speak, before they put roots down here. More importantly, before they start signing leases and landlords depend on them staying and companies become dependent upon their labor. The Trump administration, very quietly about a week and a half ago, massively expanded the class of aliens who are subject to this expedited removal. So as I told you, originally, and this has been since I believe '04, the rule was that you had to be in the United States for 14 days or less, and you had to be found within 100 miles of the border. Of course, you had to have entered illegally. And that is, the United States would know that because they would catch you and they would have no record of your lawful admission in any known port. And that could also be that you walked in and you wanted to enter legally, but you simply don't have a passport. That's also an illegal entry. So the expansion of this expedited removal it's really fascinating. They changed the number of days from 14 days to 2 years. So anyone who's been here for 2 years or less, and they expanded the area in which aliens were subject to expedited removal from 100 miles to the entire United States. And that was very quietly done. I mean, it really was just an amazing thing. There was a little bit on the news about it. I wrote a post about it. Some years ago, I had a client who got caught up in expedited removal. And at the time, John Ashcroft was the Attorney General of the United States. And I ended up finding out very quickly that the expedited removal process happens so quickly, it almost effectively deprives an alien caught up in the system of really some important fundamental due process rights. So in order to prevent my guy from being deported before his case could even be heard, I went and filed a lawsuit against John Ashcroft himself as the head of the agency that was depriving my client those important rights. That ultimately was successful in slowing the process down long enough that we could protect my client. But that, as a younger attorney, you do more stunts. But I do thank you guys for checking in. There'll be more of this coming forward, so if you want to like our page, you'll get notifications when we go live. Any other questions, fellas? All right, well, I'll be back. We'll have some more talks, and I thank you both for your attention. All right, bye-bye.